Good afternoon, everyone, and welcome to this week's afternoon program. As part of one of the South African Bar Association's initiatives, the association hosts a speaker on a weekly basis to deal with a legal topic intended to assist young practitioners with training and development, which is enshrined within the core values that we hold as an organization. It is an honor and privilege to have the Judge President of the Labour Court and the Labour Appeal Court, Judge President Basheer Waglay, to address us today on a topic of appeals to the Labour Court and what legal practitioners should focus on there too. It is a further honor and privilege to have Advocate Harley SC to conduct JP's welcome and conclusion. In terms of housekeeping, during the address, all participants shall automatically be muted. After the address, there will be a question and answer session whereby all participants shall be unmuted so that they are given the opportunity to ask their questions directly to the JP. Those participants that have a question, kindly raise your hand using the Microsoft Teams platform, whereby you can simply unmute your mic and video to pose your question directly to the JP. Furthermore, during the question and answer session, albeit the fact that all participants shall have the functionality of unmuting their mic and video, we humbly request that only the participants that is asking the question do so, and only do so once your name has been called out. With much further ado, I now hand it over to Advocate Harley SC to conduct the welcoming of the JP. Over to you, Advocate Harley.
Thank you very much. It's indeed a privilege for me and an honor for me to introduce Justice Basheer Waglay, who is no doubt well known to many of you as the Judge President of the Labour and the Labour Appeal Courts of South Africa. Justice Waglay is also a former Justice of the Labour Court and a sitting Judge of the Western Cape High Court. A fiercely private person, his sometimes lapses have been marked by occasional references to, quote, my girls, unquote, who are the nieces he apparently dotes on with avuncular oversight and concern. Before his elevation to the bench, Justice Waglay ran a successful attorney's practice in partnership with former Justice Musa, who until Justice Musa was himself elevated to the bench of the Western Cape High Court. As an attorney, his practice was varied, comprising tax matters, general litigation, and labour law, amongst others. In line with his varied practice, he has presided over and written judgments in various aspects of the law, including labour law, obviously, and criminal law and tax law. He is also a consulting editor of the Industrial Law Journal. Perhaps the most significant reforms introduced by him as Deputy Judge President and Judge President include the 2013 Labour Court Practice Manual, the housing of the Pro Bono Office of the Labour Court, and an extensive acting judges program. Each of these feats speak for themselves, and they speak to what I think are Judge Waglay's philosophy as both a judge and a legal practitioner, and give vent to the right of access to courts and the transformation of the judiciary. In 2012, when interviewed for the position of Judge President, Justice Waglay explained the heavy workload that was faced by Labour Court judges at the time. He explained that there were only 10 permanent judges who had to deal with approximately 15,000 cases. The measures which he has introduced since becoming Judge President to deal with the workload have been highly successful in reducing these numbers and in accelerating the process of litigation in the Labour Court. The introduction of the practice manual has to a large extent changed the manner in which we practice labour law today. It ensured that all practitioners and even lay people were able to navigate litigation in the Labour Court with relative ease. The provisions of the practice manual also speak to the well-known principle of the Labour Relations Act, which is the speedy resolution of labour disputes, by putting into place specific safeguards to ensure that the process is not abused and that matters are finalized with relative ease. We know now that that where an applicant fails to prosecute the review and/or application, this can be archived and that a full and proper explanation must be provided why the matter should be taken out of the archives. The practice manual also importantly ensures access to courts for lay people who have court orders in their favor by introducing a mechanism for contempt proceedings to be instituted which assists lay litigants. All of this is in line with the constitutional imperative of access to justice and the speedy resolution of labour disputes. The pro bono office in the Labour Court speaks for itself. It's important for access to justice and ensuring that dismissed employees have assistance in their matters. The pro bono acting judges week is important for two reasons. Firstly, it assists with the backlog of cases in the Labour Court as well as the transformation of the judiciary. In 2012, as I've said, Justice Waglay had explained that they had over 15,000 cases, and that has been substantially reduced as a result of these measures that he has introduced to transform the landscape of the Labour Court. Justice Waglay will today be speaking on what to focus on in appeals to the Labour Court. Without in any way detracting from or anticipating his talk, I have an enduring recollection of Justice Waglay's advice to practitioners appearing in the Labour Court, which was to, quote, avoid arguing frivolous and inconsequential matters. It is a philosophy he has always applied, often quite forcefully in both the Labour and the Labour Appeal Courts, and one which, if borne in mind, should spare the unwary practitioner many a bruise over his or her career. Without further ado, Justice Waglay.
Thank you, Mr. Ali, as always. Too many things are said all through. I don't know. Thanks. Just one housekeeping matter, and this is dependent entirely on those organizing this talk, and that is that I have no objections if during the course of me saying what I say, if someone wants to ask a question, feel free, I think, to interrupt me if the process allows it. I have no objections, so no problems with that. Anyway, I was given short notice, so I didn't prepare extensively. I think it's much better if we can interact, ask questions which I can answer, raise the issues that you might have faced, and we can deal with that. But there are a few things which I think are very important, especially for council. First, I think you need to understand that the Labour Appeal Court only, I'm sure you all know this, very basic stuff, that only hears appeals from the Labour Court. And while in the past, the Labour Appeal Court was seen simply as a full bench, as you have it at the High Court. Since 1913, with the amendment of the LRA, the SCA no longer hears appeals from the LAC. LAC is in fact the final court of appeal in all labour matters or matters arising from the Labour Court. But before we talk about the LAC and what, as council briefed to appear before the LAC need to know, let's talk about the Labour Court jurisdiction. I know people might be putting up their hands, but let me deal with this because I think it's so crucial. After so many years in the LAC, we find people still coming up, not really dealing with what they have in front of them with the proper appeal. I say this because we all know the LAC was set up primarily to deal with matters arising, and the LAC was also born out of the LRA. So matters arising from the LRA, which is the Labour Relations Act. But the Labour Court itself also has jurisdiction to sit as a normal civil court, not just as a Labour Court in terms of the LRA. It's still the Labour Court, but it sits with a civil court jurisdiction. And that happens when it hears matters that arise from the Basic Conditions of Employment Act, the BCEA. So when you're being briefed in a matter for LAC, please see what you have in front of you. Is it a matter which is an LRA matter, or is it a matter which is a BCEA matter? Let me explain. An employee is dismissed. He believes his dismissal was wrong. He has two options: to challenge his dismissal as unfair, and this he will do in terms of the LRA, which requires mediation, then arbitration or adjudication, depending on what he alleges to be his reason for his unfair dismissal. His second option is to challenge his dismissal as being unlawful. This means that he's not dealing with fairness of it, but unlawfulness. Here, he does not go through the conciliation process, but goes straight to court, to the labor court if he wants to. He can also go to the High Court if he so wishes, civil court, but he does so in terms of the Basic Conditions of Employment Act. Now, the Basic Conditions of Employment Act says that the labor court sits as a civil court to hear matters relating to a contract of employment. So when you go into the BCEA, or when a party comes to the labor court in terms of the BCEA, what it alleges is not unfair dismissal, it says unlawful dismissal. It will allege a breach of the employment contract. Okay, and his relief they might seek is either specific performance, which is equal to a reinstatement in terms of the LRA, or he could claim damages or both. Now, if you come in terms of the BCEA, which is a contractual civil court matter, it's the employee who alleges he must prove that there was a breach of contract. He must convince the court that specific performance is appropriate. He must prove the damages he has suffered. Onus is totally on him to do all that. It's very different when he goes to court on an unfair dismissal matter or arbitration. All he has to do, an employee has to say, I was dismissed. That's all. Then the employer has the onus to show that the dismissal was fair. And if the arbitrator or the court, whatever, whoever is hearing the matter, depending on the cause, the reason for the dismissal, has its primary remedy to grant reinstatement. He doesn't have to come and prove that reinstatement is appropriate. It's a remedy. If he asks for reinstatement, the court will, or the arbitrator will have to, unless there are certain circumstances which don't allow it, as set out in the Act, grant that reinstatement. Alternatively, he can claim compensation. Here again, it's compensation, which is a solatium. It's not damages, so he doesn't have to prove it. The Act says what the solatium can be, between 12 months, 24 months or less, a discretion the court has. Now, I raise this because these matters, they come to the labor court, they're very different. So when you brief to appeal the decision of the labor court, whatever it is, you come like some of them, counsel come and they want to argue that a dismissal was unfair when the matter was brought to the labor court in terms of the BCEA. You can't do that. You need to therefore establish, did this matter go to the labor court on the basis of the LRA or the BCEA? And I raise this because, believe me, 10% of dismissal matters coming to court are coming on the basis of the BCEA. People do that, and it's mostly the white collar employees who are doing that, because when you go to court in terms of the unfair dismissal route, you have to go through a long process. You have to go through conciliation, arbitration, then review, or labor court, if it's a discrimination matter, and then appeal. They think the process is much longer, whereas it's a labor court. You go directly to the labor court, skip the conciliation. It's a pure contractual civil matter, and the chances are you might be heard fairly quickly. So for quickness, they sacrifice, they take over for themselves the onus of proving everything. And that becomes a big problem later, because if they lose and they come on appeal, they can't change that then. They have to continue with the normal civil rules that apply. And more importantly, of course, is, the labor court is a court of law and a court of equity. That is when he sits in terms of the LRA, disputes relating or coming from the LRA. But when it sits as a civil court, dealing with a matter in terms of BCEA, a contractual claim, it's sitting as a civil court, not a court of law and equity. It only sits as a court of law. And if it sits as a court of law, when it comes to cost must follow the result. When it sits as a court of law and equity, inevitably there is no cost order, because there is in terms of the Act as well, this view that if the relationship is going to continue, then the court should avoid granting costs unless the matter was malicious or there was no basis for it whatsoever. So you have that discretion. But it's a fairness issue. Is it fair or not fair? The other is pure law issue. So you need to understand that, and it's crucial that when you are briefed in an appeal, look at the statement of case, look at the notice of motion. And please remember, it's not just you. I have had senior counsel who hadn't looked at that. They simply came because the judge doesn't say, I'm hearing this in terms of the BCEA, he just hears it and he gives a judgment. And counsel come in and argue. Senior counsel once argued that the judge got it all wrong. He got it lawfulness when it should have been equity. And I asked him if he had read the statement of case, because it was a case in terms of the BCEA. So please don't do that. Don't go to court and argue something purely because you think, oh, it's a dismissal matter. It's a matter which comes from the Labour Court. Labour Court dismissal, they deal with the unfair dismissals, and therefore the onus is there and onus is this. Look at it, and that should be your starting point. And it's a very crucial starting point to understand. Then there is this myth, you see. The myth is that junior counsel, or when they are briefed by themselves, and middle juniors for that matter, they are told what the case is about and they prepare. They look at the record, they read the record, prepare heads of argument and get to court. You see. Now, I say there's a myth around this because you know when you started off practice as junior counsel, you were briefed to do matters in the High Court, mostly motion court matters, number of them are unopposed matters. The first thing you do when you go to court, when you argue, when you're seeking that order, you stand up and you would say, my lord, the papers are in order, and ask for an order. Papers are in order, and I ask for an order in terms of prayers A, B, and C. And the court relies on you when you say that the court papers are in order. It shouldn't be any different, and it's not. When you go appeal a matter, or when you're in any court, any appeal court for that matter, to consider the whole record to see if the papers, everything is done properly. And when I say this, I must tell you, it's not just the appellant. Even the respondents don't seem to bother to see if everything's done properly. You get to court, the first question the court asks you, where is the power of attorney to prosecute this appeal? And the counsel will stand up and say, I don't know, my lord, I'm sure the attorney's done it. Now, I can understand counsel not looking for a power of attorney because one would think, okay, that attorney will do it. If that's the only problem, courts and judges are not too strict about that. They will tell you, please tell your attorney to find it or file it by the next day. But the counsel, when they prepare the heads of argument, the very basis, the very first document they should be finding in that record is a notice of appeal, because that sets out the parameters, the grounds of the appeal. I know this is normal and you know, all of you know that, but believe me, we have matters coming to court and people have not filed a notice of appeal. Now, how can a court hear an appeal where there is no notice of appeal? Because that sets out what the grounds for appeal are. Absent the notice of appeal, there is no appeal. So please look for these things. You are required to make sure that the papers are all in order. Don't just look at the record and prepare your heads and come to court. And also, I remember a matter in the High Court where counsel stood up and said the papers were in order when they weren't in order. You need to check the rules. And I had a sequestration matter before me, unopposed. Counsel stands up and says the papers are in order, asks for an order in terms of A, B, and C. And I asked counsel, did you read the papers? And she said, yes, she had. And I said, are you satisfied everything's there? that I can grant the order? She says, yes. I said, you sure you read the papers? She said, yes. I said, where is the benefit to creditors? Isn't that a requirement? She says, no. At least then she had read the papers, because she didn't even know now that they need to be a benefit to creditors. So that's a problem, but therefore you need to have when you're doing heads and when you're preparing, have an aide de memoire. See what the matter is about. A good advocate, no matter how many matters he's done exactly the same matters, he would go back to his aide de memoire to see in this case if he's actually dealt with everything. You never know what you're going to miss. So be careful, read the rules, go through the rules. You need to. I know it's your attorney's job to do that, but attorneys sometimes miss things. And the attorney is not standing up before the court to argue. He's not going to face the wrath of the judges. You are. So you need to make sure that when you stand up and the judge asks procedural issues, that you can answer them. If the court asks you, where's the power of attorney? Okay, that might be excusable. Say, no, I didn't check on that. It's fine. You can be excused. The court asks you, where's the notice of appeal? And you say, well, I don't know, it should be in the file. Don't give me that answer. I will simply strike the matter off the roll immediately. How did you prepare your heads without the notice of appeal? So look at that. And then the other issue I have in the Labour Appeal Court. We have objections to cross appeal. Oh, you won't believe, nearly every cross appeal there is an objection from the appellant. Why? Because while the appellant had applied for leave to appeal, or when leave to appeal had failed, had petitioned to the LAC and got his petition, was successful in his petition, here comes the respondent and simply files his cross appeal, notice of cross appeal. And the objection is he hasn't applied for leave to cross appeal. Read the rules. The rules don't require you to do that. If there is an appeal, once you file notice of appeal, the respondent can automatically cross appeal as long as he files his notice of cross appeal within a particular time limit. So don't raise objections like that. And talking about that, and you briefed in a petition, and you draw a petition, and the respondent replies to it, or responds to it. I always get confused with that. You don't have a right of reply to that. It's a petition. It's only two sets of papers. The petition, founding affidavit, and the answering affidavit. There's no replying affidavit. And we get 200-page reply. You want to give a cost order against the attorney. It's your job when you brief to protect your attorney, to make sure to tell him, I have read the rules, there is no provision for that, we can't do that. So look at those things when you prepare. Then we talk about, I must tell you that 60% of the records we receive in the LAC do not comply with the rules. And our problem is that we normally prepare quite well for our appeals, and we try to find ways just to hear them. But we're reaching a point now because the number of appeals are getting more and more, and we might not hear the appeals, not because counsel, and it's not counsel's fault most of the time, in the sense that they are not required to make sure that the record is right and so on. But how do you prepare heads? When you're preparing heads, you can see the record's either incomplete, or it's not properly paginated, or it's not in order, or it contains documents which shouldn't be there, and the rules are so clear as to exactly what should be in the record. It's your job to call your attorney in and say, hang on, I can't do heads on this matter. If I go to court, the judges are going to attack me or, ask me questions. What do I tell them? You haven't done a record properly. I know they've paid a fortune to these companies who complete a record, who actually collate a record. Many of them don't seem to know how to do that. And it's no different to how it's done in the SCA. It's no different to how it's done, I think, also in the High Court full bench. And yet we get records which starts with heads of argument in the Labour Court. Since when do heads form part of the record? Any attorney should know that. When counsel gets that record to draw his heads to appear, he should know that this record is not right. We had a matter 2 weeks ago where half the record was missing. The evidence, the cross-examination of the main witness was missing. And the parties had argued that matter in the Labour Court. And now they came to the LAC. I mean, I know you will say, how come the Labour Court entertained it? That's the Labour Court issue, and I had to deal with that. But when counsel was briefed in the matter in the LAC, did the counsel not see half the records not there? How could you come in a review matter, argue that the arbitrator did not apply his mind when you don't have half the record to show whether he did or did not? So, as counsel, I hold you responsible to ensure that you have gone through the record, that you've ensured that it's complied with all the rules. Substantive issues, no one can guide you. That's something you need to look at the law, and please look at the law as it exists now. Don't do what counsel did a month ago. He comes to argue a matter. He gives me an authority from the SCA years ago, which has been overruled so many times. And then I asked him, why should I follow this authority? And his answer was, it's the SCA and you are bound. I asked him, did he know what the status of the LAC was? He says, whatever it is, SCA is much higher. SCA is not high, it's the same. It's persuasive. But in that matter, at least if it was a matter which dealt with the issue at the present time, wasn't old and overruled, he might have at least argued that's persuasive value. But it was old. And he comes and he says, because the SCA, I must follow it. Please don't do that. Every matter you get briefed for, you're getting paid. Work on it. Don't come take chances. And don't take chances in the LAC. We actually prepare and we're always ready and we discuss this matter. We have conferences on each matter. No matter how simple it might seem to you, but the full bench, not the full bench, the appeal court, LAC court, we will sit and discuss the matter before we hear it. And we know exactly what the problems are. And you need to know that. That's how you earn respect. And that's how you will do well as well. Yeah, I mean, as I was saying, 60% of the files, the records we receive, do not comply with Rule 10, Rule 11, Rule 12, Rule 13, Rule 14, Rule 15 in one way or the other. Either all or most of these rules. And it's shocking. It's unacceptable. In many cases in the LAC, sometimes the appellant has not complied with the rules and been successful, while we would have considered granting him costs. We don't, because of the state of the record. You see. So please make sure you've read the record, you've looked at the rules, they comply, and that you look at the case law as it exists. You need to invest. If you don't invest, have access to the Butterworths or to the LRA to see what is the latest developments in the labor law on that field which you're going to argue. Don't argue something which happened 10 years ago, 15 years ago. It doesn't apply. If you go back more than 3 years, you know there's a problem. Everything changes. Labor law is law which you need to learn, then unlearn, and then relearn. That's how it goes. Things change, they're very fluid. I mean, just the test for review. In the last 10 years, I think we've had so many versions. You know, I call them different shades of reasonableness. Shades of reasonableness have changed over the years, and you need to keep in touch with it. In fact, any field of law, you need to keep an eye all the time on the field you're working at, because it changes all the time. That's a half an hour discussion. I rather have to talk about things when, I mean, Labour Appeal Court is no different to any other court. You need to, what are the topic suggests that I must look at what you need to be very careful about or consider. Nothing new. Read the rules. understand what the issue is, be very careful as to what the matter is. Is it a LRA matter? Is it a BCEA matter? Is it an Equity Act, Employment Equity Act matter? Because in each of these acts, different rules apply, in the sense that you might be compelled to go through conciliation, like an Employment Equity Act, before you can go to court. If you don't do that, there is no jurisdiction. And please be careful when you come and argue condonation. Don't argue. I mean, that when the condonation goes to the root of jurisdiction, that is when the Act says you need to do something within 20 days and you haven't done it. And the Act says, look, you need to file a statement of case, let's say within 20 days. If you don't do it within 20 days, then the court has no jurisdiction to entertain that. And that's because it goes to jurisdiction. Parties can't come to court and say, we've agreed, the respondent has said that he's not objecting to the late filing of the statement of case, and so we ask that the agreement be made in order of court that condonation is granted. Between the two of you, you can't agree to give the court jurisdiction. Court will decide that. Same with the review. Just last week, last week we had acting judges, and the acting judge phoned me because I had mentioned this to them, that be careful, you can't give a review matter. You can't make a review agreement and order of court, where you can't say the parties have agreed that this review should be deferred back. No, you can't do that. Only the court can consider and grant that order. It's a review of an award. It cannot be rectified by the parties themselves. The court needs to make that order. It can't make an agreement in order of court in that respect. It might totally agree with what is being said, but it must say that. And it must say, I've considered it, and I agree with the parties that this is an issue, and for that reason I agree that this matter should be referred back. But don't make an agreement in order of court. You'll have a problem with that. So think about these things. Sorry, there's two hands up. Ford and Ahmed, I think. Ahmed, do they want to ask something? I don't know. Yes.
JP, I've got three quick questions, if I may just run them off you quickly.
Yeah.
So the first question I have is, why is it that the Labour Court sits in only 3 provinces? In as far as my practice being practicing, I've dealt with matters in Namibia, where in Namibia the High Court, the Labour Court, sits as part of the High Court of that division. So would it not make better sense, and for purposes of access to justice, for every division to have a Labour Court? That's the first question. The second question is, does the Labour or the Labour Appeal Court at any point envisage case lines in order to get away from all the paper-based exercises and the volumes of paper that comes with bringing applications to the Labour Court? And then the last question I want to deal with, JP, has to do with the frivolity of issues giving rise to appeals. And the example I'd like to raise there is a judge in the Labour Court, instead of striking the matter of the roll when the parties didn't arrive, when the matter was called at roll call, dismisses the application on the merits, resulting in the parties now having to apply for rescission, which could have been completely avoided had the judge just considered what does the rule say and what does the practice manual provide. Both the rule and the practice manual provide under such circumstances the matter should be struck from the roll.
Okay, let me hear the other 2 questions and I'll answer all of them. Other questions from Ahmed, is it? Ahmed or Ahmed, I don't know.
Thanks, JP. I have a question. You mentioned that one needs to be fluid in the current changes. You further discussed in great detail as to jurisdiction. My question surrounds the recent judgment before the Constitutional Court surrounding the issue of whether, in terms of the Labour Relations Act, the High Court and the Labour Court enjoyed concurrent jurisdiction over an alleged unlawful termination of a fixed-term contract of employment, that being the Baloyi versus Public Protector and others case. The Constitutional Court affirmed that Section 1571 of the Labour Relations Act does not afford the Labour Court general jurisdiction in employment matters. The Constitutional Court further affirmed that by virtue of Section 1572 of the Labour Relations Act, the High Court and the Labour Court share concurrent jurisdiction in respect of employment-related disputes over which the Labour Court does not have exclusive jurisdiction. My interpretation of such is that the High Court's jurisdiction is not ousted by Section 1571 of the Labour Relations Act, simply because the dispute falls within the overall sphere of employment relations. The Labour Court's exclusive jurisdictions extends to disputes for which the Labour Relations Act creates specific rights and remedies, unfair dismissal disputes being such an example. Whilst the Constitutional Court held that that nothing in the Labour Relations Act requires the applicant in the aforesaid case to advance such claim in a Labour Court, the Constitutional Court held that the High Court had erred in dismissing the applicant's application on the basis that it was essentially a labour dispute and that the High Court jurisdiction was not engaged. The Constitutional Court remitted the matter to the High Court for hearing de novo. Now, my question to you, JP, is that in lieu of this Constitutional Court judgment, what is your submission on one, bringing a labour matter and or civil matter in terms of the BCEA before the Labour Court, whilst we are able to bring it before the High Court?
Thank you. Let's start with your last one first. That is exactly what I was dealing with.
Okay. Before we, if you want to answer all of them at once, there's a last question by Mohammed Patel. Mohammed Patel, do you want to pose a question to the JP now, and then he can go through all of it together, if that's fine with you, JP?
That's fine, thank you.
I'd like to thank you for having this webinar. It is rather informative, and it is very, very practical in nature. And as a junior practitioner, JP, what you've been stating about being prepared for matters, I've seen personally through this year of practice of how unprepared juniors are, even some seniors, JP. JP, I had two questions. The first question, I'm going to piggyback off what Bart was asking with regards to case lines. In line with going to a paperless system and moving away from the normal bringing the court files to court, in the Labour Appeal Court, JP, would you consider improving the infrastructure of the court system in general? I mean, I've been to many courts and in person, and I'm struggling with having access to Wi-Fi, having connectivity issues. So is that something within the JP's plans? And the second question, JP, I have is with regards to the earlier when you stated about the condonation. And the condonation, when you're requesting non-compliance, I understand when you say that it's up to the court to decide, but I'm struggling to understand why shouldn't we ask the court for condonation when there's a blatant misregard in respect of the days and the rules stated? Thank you, JP.
Okay. Let's start firstly with the thing about jurisdiction. I think the Constitutional Court was simply saying that when you're dealing with an LRA matter, then only the Labour Court will have jurisdiction, but you're dealing with BCEA, where it specifically provides that the Labour Court has civil jurisdiction with the civil courts. And that's why it found that the High Court was wrong in saying it was a Labour matter, a contract matter, so they must go to the Labour Court. The Act is very clear. It's a civil matter. It can be heard either by the High Court, the Civil Court, or the Labour Court. The Labour Court has jurisdiction in a contractual dispute, employment contract dispute, I must specify. If there's a employment contract where there is a dispute arising from, then the Labour Court can hear the matter, but it does not oust the jurisdiction of the normal civil courts. I think that's effectively what the court was saying. That's my understanding. I haven't carefully looked at that judgment yet. I've been too busy trying to manage about 62 acting judges in the last 2 weeks, but I will look at it again. Then coming back to the issue of condonation, there's two types of condonations. One goes to jurisdiction and one goes to an agreement where the parties simply file late. The rule says that you must file your reply in 10 days and you file 12 days. There it's very clear, and it's met with the directives, which says, look, that sort of thing parties can agree to, and if there's no objections, in fact, then it doesn't matter. It will be taken as file time you leave unless there's an objection. It's only when the condonation, when you're out of time and the time limit is prescribed by the Act and therefore it goes to jurisdiction, then the parties cannot agree, because you cannot by agreement confer jurisdiction on a court of law. So it depends. Replying affidavits and those things, they're out of time, you can agree to whatever. Only when it comes to a jurisdiction or issue, then you cannot agree, and it must go to, there must be an order by the court. The court must consider it. With regards to why Labour Court only sits in 3 provinces, it sits in 4, but we also have a Labour Court now in Limpopo. We have one in what's the latest place? We will have a Labour Court in every province where there is a High Court. What we say is, although we have like a Labour Court in Limpopo, it sits maybe 1 week a year, 1 week a term, 1 week every second term. It depends on the matters. If any party comes to us as an applicant or respondent and say to us, look here, we have a matter where all of us come from the Free State and we would like to have the matter heard there. Yes, the Labour Court will come to Free State and hear it. We've done it. We've done it in Free State. We've done it in the Northern Cape. We've done it in Polokwane. We have a court there. In what's Nelspruit, I forget what's it called now. We have a court there. So we have a court everywhere. We just don't have and don't see the need at this time to have a full-time registrar there and officers there, because in the law, okay, not in the Bar Council Journal, but in the De Rebus, which is the lawyers magazine, it has been published that any attorney or party can approach the Labour Court, can approach me to say they want the matter heard in a particular province, and we will gladly, if both parties agree, or even if a party doesn't agree and there is good reason for it to be heard, we will. We've had a matter in Polokwane which ran for I think a year, because there were so many employees involved. We will accommodate that sort of thing. So the fact that there's only in 4 provinces permanent Labour courts does not mean that that you are bound to come there. You can talk to the registrar and arrangements could be made to have your matter heard anywhere in the country. As far as case lines are concerned, the terrible thing of being an attorney, I was an attorney for 16 years, is that your secretaries do everything. So when I joined the bench 22 years ago, I only knew what a computer looked like. I have now learned so much more. Now to go to case lines is going to make my life absolutely difficult, but I must tell you that we're learning every day. I know the High Court does it beautifully, and we are looking at it. We're considering it, because you're right. We cannot destroy our own forestry simply by producing papers, and lawyers are known to produce papers like it's unbelievable. I mean, simple thing of a review where you simply have to allege that the decision of the arbitrator was not reasonable. You will find a 40-page affidavit raising all sorts of things which are totally irrelevant. If you had simply said it was unreasonable and do a half-a-page affidavit, you'd get the same result. But it's lawyers. They churn out paper like no one else, no other party. But it's true, we are looking at the case lines. We are looking at how we're going to manage that if we can. We're working with the High Court on this issue, and hopefully, but not next year, maybe by the year after, we'll be in line with everybody else. Striking off, absolutely right. I'm going to raise this matter with my judges. We have a judges meeting on the first day of every term. I just need to make a note of it. It doesn't make sense to dismiss a matter when the parties are not there, or it makes sense to strike off, unless, of course, the matter has such little merit that striking off for the matter to come back before another judge is a total waste of time. Then it's different, because then even if someone applies for rescission, it's very unlikely to be granted, because there's no merits in anything in that matter. And we have matters like that, believe me. So if it's that kind of matter, then I have no problem with the judge dismissing it. But if there is merits, and then you can strike it off, because the parties must still come and explain why they were not in court. And with the pandemic as it stands, it seems that so many people work from home, they're not connected properly, the Wi-Fi doesn't work. If you email it, the postman definitely doesn't deliver, whether it's registered mail or not. So we do have that kind of issues which arise every time. So I will raise this. But as I said, yes, striking off is the primary sort of thing to do. But when the matter itself, after having read a file and you know there's absolutely no merit in the matter whatsoever, then I don't see any reason why it shouldn't be dismissed. Because then you can come with your rescission application, because you still have to show when you apply for rescission that there's merits, good merits for you. If there isn't, you're not going to get your rescission anyway. Then what else was there? Great. Oh, I have difficulty reading my notes sometimes. Appeals to, I think I've dealt with everything. If not, you can just raise it again. Thank you.
Thanks, JP. There's a question from Advocate Harley SC. Advocate Harley, you can simply unmute your mic.
I don't think that I had asked a question. That might have been an earlier misjudgment of my laptop.
No, in fact, let me assist Advocate Hali. JP, we had a discussion, myself and Advocate Hali, yesterday, and the question that he indicated that he might want to pose is, and I'm perhaps stealing his question, is often when you apply or petition the LAC for leave to appeal, now the LAC need not give us reasons for the decision, simply to indicate, well, the application is dismissed. And the question that he raised with me yesterday is, what does the LAC at that point in time take into account when a petition is brought and a petition is then not granted? And what Advocate Hali indicated to me yesterday is the fact that it appears that it's only sort of matters that raises constitutional issues that make it through, as opposed to matters where it's just a genuine issue pertaining to that, the fact that the judge might be wrong insofar as the law, the facts are concerned insofar as the issue brought on review.
Absolutely not. The LAC, every petition is handled by 3 judges who sit at home, read the petition, and then we get together and discuss it. It's not simply a constitutional issue matter, it's a matter of the merits. There's a petition, what is raised in the petition is what we consider. So in refusing the petition, of course we don't give reasons, because it's an international and standard practice when it comes to a petition, which is wherever there's a petition, that you simply say that the petition is refused because those hearing the petition, the judges, are satisfied that the judgment is correct, or that if the judgment is not correct, that there isn't an issue which needs to be considered. Sometimes, let me tell you, the other way, what happens is that we feel, the judges, not we, I shouldn't say we, the judges sometimes feel that the judgment is absolutely right. But the issue is one which must be aired by the LAC. It's a very important issue which has never been discussed by a higher court, only by the Labour Court, and it's time that it's properly aired before the Labour Appeal Court, and they can decide whether, you know, that judgment must stand, because it's such an important issue. So even though they might feel that the judgment is totally correct, there's an important issue to discuss, not a constitutional issue. You know, it doesn't have to be a constitutional issue at all. Like a 197.4, you know, something to do with the sale of business. It might, we feel it might be right, but we need to discuss it. Same with the restraint of trade. Sometime a new issue comes up which hasn't been dealt with neither by the SCA or anybody else on a restraint matter. And we think, because, you know, we hear more restraints than any other high court in the country, and we think, yes, maybe the Labour Court got it. We believe it got it right, but it's an important issue and it needs to be aired, needs to be discussed by a higher court than the Labour Court or the High Court. And therefore, we would grant leave to appeal. And therefore, sometimes you find that even though you got leave to appeal, you've lost the appeal. Doesn't mean that if you granted leave to appeal, you're going to win. But let me tell you, we'll never give reasons, nor does the SCA nor any other appeal court in the world. We can't do that. I mean, you would be surprised at the number of petitions we receive. The average right now, it appears to be about between 10 and 15% of petitions that are granted. Of the rest, 85%, 20% would have had some merit, and we can understand why they brought the petition. But 50% are so useless that sometimes it's with great reluctance that we haven't ordered cost, or we haven't ordered cost because there was no opposition. Sometimes parties simply don't even bother to oppose, thinking, knowing that this petition is so much without merit. So, but please remember that is one of the reasons why when you get your petition results, you will always be informed who the judges were who heard your petition. So you know who the petition was before which judges. And rest assured, it's properly considered and debated. Okay. Thank you. Anything else?
Thanks. There's a question from Andrew Goldberg. Andrew, you can simply unmute your mic.
Hi, good afternoon, JP. There are two questions that I've got to ask you. One is with the Constitutional Court's decision that now with regards to costs, if you hand down a costs order in regards to the petition, do you have to give reasons? The second question is, can the Labour Appeal Court take on a matter of its own accord, like restraints of trade and Section 77 applications, which are so fuzzy with, and we don't know what's going on with the Labour Court in that regard. So one decision goes one way, one decision goes the other way. Surely the Labour Appeal Court can take on a decision of the Labour Court and decide that it itself will clarify the issues in that regard.
If you feel so strongly that the decision is so bad, then you can come in on a pro amico basis or something, but we will never simply on our own go around and shop for doing matters, even if the matters may be contradicting each other. If there is no leave to appeal, we will not simply take it on. On the cost issue, I think the Constitutional Court requires us to give reasons. No problem with that. Yeah. Yep.
Thank you so much, JP. Is there any further questions from the participants? You can simply unmute your mic. Sorry, there's a question from Makia. Makia, you can simply unmute your mic.
Good afternoon.
We can barely hear you. We can hear you now. You can go ahead.
You can hear me.
Yes. Go ahead.
My name is Johannes Makai. I'm an attorney. JP, mine is not a question as such. I'm just asking, are we going to get the recording of this session? That's all I'm asking, JP.
I'm just a guest here, sir. I don't know what you're going to do.
I just interrupted that. Yes, the recordings will be made available upon the South African Bar Association website. Thank you.
Thank you so much.
If there's any further questions, you can just kindly unmute your mic. All right, JP. I think I can hand it over to back to Advocate Harley SC for your conclusion in that regard. Advocate Harley.
Thank you to everybody, and thank you, of course, especially to Justice Basheer Waglay. We thank you so much for your always practical, always very, very clearly explained input in this matter. We just insofar as the discussion between myself and the questions that I raised concerned with respect to Bound Court is not captured quite what I said.
As counsel will say, never trust an attorney. And as an attorney will say, never trust a counsel. But in this case, there are two counsels, so it's even more difficult.
Yes. Yeah. Having said that, Justice Waglay, it seems that the quote that was attributed to you in the Day Rebus to avoid arguing frivolous and inconsequential matters encapsulates exactly what you've said to us today. If one can summarize what has been said today, I think it would be this, that at the start of everything, counsel should carefully read the rules. From that, to prepare a checklist of all matters that need to be attended to. Satisfy yourself that you've read through all the papers thoroughly. Make sure that the appeal is properly before the Labour Appeal Court. This is in relation to jurisdiction in particular, and in relation to the notice of appeal, that there is a notice of appeal and that all other documents that ought to be there are indeed there. And then, of course, ensure that the argument that you present is entirely consistent with the papers and with the pleadings that have been filed before the Labour Court. And when it comes to questions of condemnation, make sure that if condemnation is required as a statutory requirement, that there's a formal application before the court, and if it's a matter which relates only to the rules or to the practice manual, you can then agree between the parties. And then, of course, Justice Waglay, it remains only to say thank you so much for the valuable input that you have been provided to us, and hopefully this will make us all better practitioners. And when we do appear before you in the future, from amongst the 94 people that now appear there, you won't see any of the problems that you've encountered in recent times.
Thank you. Thank you, Mr. Hari. Thanks for having me, and it's a pleasure to have been here. Okay, thanks.
What remains is to sincerely thank Judge President Basheer Waglay for his reflective address, appreciation to Advocate Harley SC for his pleasurable welcome and conclusion, and to all those that have participated virtually and shall be watching this session at their leisure. These sessions are indeed recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. I thank you.
Thank you.